Let's go to Mpumalanga now, where the Nelspruit Magistrates Court is delivering judgment on the bail application of Sipho Mkhatshwa, one of the three men accused of murdering Hillary Gardee. Mkhatshwa, together with Philemon, Lukhele and Mduduzi, Gama, are facing charges of murder, defeating the ends of justice and conspiracy to commit murder. Let's listen into the judgment.
The fact that there's a young baby, that is peculiar, but the child at this stage is with the birth mother who is taking care of the child. So taking into account the nature of the charges, the evidence on record, and with reference to the case law, I do not consider that the factors mentioned are exceptional by the applicant. But the court must still consider, with reference to the Constitution, whether it's in the interest of justice for the release. Section 60, subsection 4, must be read with sections 5, 6, 7, and 8. Just to explain, section 60, subsection 4a, you look at subsection 5. 64b, you look at section 6. C, you look at 7. D, you look at 8. And for E, you look at 8a. It is important to keep in mind that although there are 5 grounds mentioned, that's when I refer to the likelihood. But if only one of these grounds is established, it will be sufficient to find that the interests of justice do not permit the release. In respect of section 60, subsection 4a, Mr. Mkhatshwa pointed out that there are no violence-related charges against him and that there are no public protests as a result of his arrest. As proof, he submitted Annexure T as proof that the complaint of domestic violence that was made was set aside. The fact that there was a complaint and that circumstances of that setting aside is however not before the court, but I still accept that it was set aside. There is no such order. Counts 1 to 8 in this charge sheet are all violence related, and the circumstances of count 8 appears to be problematic for the accused. Count 8 alleged it happened whilst he was in custody during consultation, and the result was that the names of victims were not made known even on that charge sheet in order to protect the witnesses. So if I look at section 60, subsection 5a, it appears then to be applicable for consideration in this matter. Further, although it's not a determining factor, it was known that with every court hearing, there were either public support for the deceased and the family and or for the accused persons at court. I also indicated to Advocate Nkosi for the applicant that references to other High Court case applications and or subjective opinions on social media has no relevance when he wanted to put questions about that to the investigating officer. Myself, I also dealt with an application that was brought in court for the recording of these proceedings to be televised internationally. So it is quite clear that there is a public interest. But I agree with Mr. Mkhatshwa that there was no objective evidence to show that his release may result in public unrest. I do not have evidence in that regard or the words of the investigating officer. If I then look at section 60, subsection 5a, that deals with the degree of violence towards others implicit in the charge against the applicant before court. The charge of murder dealt with an execution-style shooting in the head of the deceased. Then there were also threats of eliminating a witness or witnesses with reference to the charge against the applicant. So section 60, subsection 5b, the threat of violence is indicative and it was aimed towards a witness who may or can testify. I take that into account. In respect of section 60, subsection 4b, Mr. Mkhatshwa pointed out that he does have travelling documents, but do not intend to travel at any time in the near future, and he also submitted by any order of court that it can be kept for safekeeping. The problem later is that the family ties in Swaziland were not disclosed. Not simply visiting their family, the accused also submitted that to counter, bail conditions may be considered to the effect that he must stay in another province, not only for his own safety but also for others, but then oversight to monitor may be problematic, but it's still an option. The accused also indicated he holds several immovable properties, houses, so that the bond is quite strong. That I will take into his favour. In respect of section 60, subsection 4, C, if I refer back to the C section, where there is a likelihood that the accused, if released on bail, will attempt to influence or intimidate witnesses or conceal to destroy evidence. In respect of section 60, subsection 4c, the accused indicated in his affidavit that although he does not know the identities of the witnesses, that he has no intention to harm them or interfere with the investigations. The investigating officer explained that with the adding of count 8, it must be viewed in a serious light that he on purpose did not disclose identities, as it appears from that suggestion from the attorneys on how other inmates could be trusted as witnesses, and they conveniently overheard conversations that there are indeed speculations who these witnesses are. He pointed out these witnesses trusted the state in making statements. They agreed to testify, and as he never indicated their identity, he was clearly unhappy or disturbed by suggestions on who these witnesses may be. In respect, the fact that the identity is withheld suggests the complexity and the position of the accused is difficult. It stands in direct contradiction when he merely said, "I am not going to interfere," and his actions then later suggest the opposite. In this case, I refer to the Matabula matter that says the court cannot simply rely on what you say, you parrot the terms, the court must look at the actions. In respect of section 60, 4D, where there is a likelihood that the accused, if released on bail, will undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including bail, the following. The investigating officer indicated that despite being in prison, the accused still made plans to deal with witnesses. That resulted that the accused persons was then moved to another prison, namely Barberton Maximum Prison. State argued it shows that the undermining of justice system is very relevant. In respect of section 60, 4E, it states where in exceptional circumstances there is a likelihood that the release will disturb the public order or undermine public peace. Accused pointed out that his release will not disturb public order or undermine the justice system. Further, that there were no sense of shock or outcry, and he also pointed out his life is not in danger. The grounds suggest actually, when the court needs to consider the factors, I must look whether there are circumstances. I cannot simply accept, and because it's exceptional, there must be something more than likelihood. The murder was allegedly an execution-style murder. The confession indicated the political mission, and further consideration is whether the accused own safety or any of his family is in jeopardy. Further, will the release undermine public confidence? What does people then say if they are released? I already pointed out that there were no suggestions that was testified about this. I do not have any, and I do not have objective evidence from the investigating officer, so I will not speculate on this ground. But looking at all the aspects, and the grounds that I did mention, it appears to the court that the grounds in section 60, subsection 4A and C are clearly present. And I pointed out that if only one of these grounds are present, then it shall not be in the interest of justice to grant bail, and I have more than one ground. The Supreme Court of Appeal in State v. Sivela made it clear, that's 2010, JDR 1471, and I quote, in determining whether an applicant for bail may, if released, commit further offences, a court not being blessed with prophetic foresight can legitimately rely on past alleged conduct of such of an applicant. The appellant's alleged conduct, that's now in the case, points that it is a possibility which cannot be said is so remote or fanciful that is likely to continue to commit further crimes should he be released on bail. In that case, the Sivela matter, the court held to release the appellant on bail under those circumstances is not in the interest, unquote. If I apply all this to the case before myself, the grounds or fears in section 64A and 4C are relevant. A, where there is a likelihood that the accused, if released, will endanger the safety of the public or a particular person appears to be there. C, where there is a likelihood that the accused, if released on bail, will attempt to influence or intimidate witnesses or conceal appears to be there. These involves elimination of crucial witnesses for the state. That is count 8. And those witnesses are needed for the proper functioning of the criminal justice system. I cannot ignore this fact, especially where lives of witnesses are at stake. And if I consider that, it cannot be in the interest of public or the administration of justice. Mr. Mkhatshwa, please stand. Considering all these aspects, I will make the following rule and order. After considering and evaluating the statements, applying the law to the facts, the court is therefore of the opinion that the accused, Mr. Sipho Lawrence Mkhatshwa, did not discharge the onus as contemplated in section 6011A of Act 51 of 77 and the grounds in section 60 subsection 4A and B and C, A and C at least. He failed to show that there are factors which in the interest of justice permit his release on bail or that there are exceptional circumstances. Accused failed to adduce independent evidence of innocence or regarding the strength of the state's case. Therefore, the application for bail is not granted and bail is refused. Thank you. I did type my judgment and I will add it to the charge sheet for benefit. I looked at the charge sheet and I noted that on a previous occasion the matter was postponed to the 22nd of August. That was before my colleague, Mr. Morris, to the 22nd of August for serving the indictments, and that the bail applications were then postponed to different dates. So, Mr. Mkhatshwa, your matter is now postponed until the 22nd of August 2022 for indictments. Until then, in custody, no bail. Thank you. Court will adjourn.
All right.
All right, murder accused there, Sipho Mkhatshwa, denied bail by the Magistrates Court in Mpumalanga and Nelspruit. Among the reasons, it would not be in the interest of justice to see him out. The magistrate was pointing out that if the accused is released on bail, witnesses may be in danger. It's not in the interest because, among other things, there were witnesses who testified and were willing to testify to the state that they heard plots to interfere with key witnesses, state witnesses, and that judgment was saying that For that reason and others, bail will be denied. Also, Mkhatshwa did not disclose that he had family ties in Eswatini. He spoke about his travel documents, but he did not speak about the fact that he had family ties, also the fact that he had multiple homes. The magistrate did say, though, that there was no evidence that Mkhatshwa's release would cause unrest. However, there are a number of issues that are looked at when determining whether a person gets bail or not. And on more than one of those, the magistrate decided that it was not in the interest of justice for the accused to get bail. We are following that story and we'll keep you updated.